All right. Response in opposition to defendant Nichols' motion for mistrial and severance. This is the one I read on Friday by Bruce Harvey, Attorney Bruce Harvey. Attorney Bruce Harvey, his writing is excellent. Excellent. The state of Georgia hereby moves this honorable court to deny defendant Nichols' motions for mistrial and response in opposition to defendant's objection to trial judge substitution. In support of this motion, the state shows this honorable court as follows. Oh, she has an introduction. A mid-trial substitution of a judge do not violate the 6th or 14th Amendment rights to trial by jury. In my opinion, if it was a week-long trial, maybe. We are 8 months in. Folks, we are 8 months in to this trial. That's a serious difference. 85 or 84 witnesses in. We're in the middle of the prosecution's case in chief after 100 days of trial. In paragraph 1, defendant Nichols asserts the mid-trial substitution of the trial judge violates his 6th and 14th Amendment rights. The mid-trial substitution of a judge does not violate the 6th Amendment or 14th Amendment rights. This claim was made in McIntyre v. State, and the Supreme Court of Georgia assumed for purposes of this appeal only that these rights are implicated by the mid-trial substitution of judges. This is important for purposes of this appeal only. Now, this means that the Georgia Supreme Court said this is an exception. We are only applying this to this trial and nobody else. Now, since it's a Georgia Supreme Court decision, prosecutors will still try to use it in other cases, and they probably have already. Nana Misty, thank you for your $5 super chat. They are all so crooked they make a slinky look straight. I don't understand how this is not misconduct. Neither do I. Neither do I. And ultimately rejected that claim. However, when it did so, the court specifically referenced People v. Espinoza, in which the Supreme Court of California held that a mid-trial substitution of judges does not violate those rights. People v. Espinoza. Let's see. How long was that trial? That is, the original information had charged Espinoza with assault. So it was an assault trial. Let's see here. I am here reading. After a jury trial, Espinoza was found guilty of assault with a deadly weapon. Is this the correct one? I have to check again. Oh no, this was a death penalty case. All right, so not as an assault case. This is the one. Death penalty. Exclusion of evidence about a proposed polygraph test. Yeah, polygraph test. I'm so happy those are completely excluded. Animosity between the prosecutor and defense counsel. Yeah. Jury's comment on the defense witness. Instructional error. Where is that? Ruling, here it is. Ruling on the automatic application to modify the verdict by judge who did not hear the entire guilt phase trial. So, the guilt phase of defendant's trial commenced before Judge Kenneth Ferguson, who conducted the proceedings until, during the presentation of the defense, he became too ill to continue with the trial. The presiding judge of the San Quentin County Superior Court then assigned Judge Peter Sayers to substitute for Judge Ferguson pursuant to section blah, 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 blah. Which means this case does not apply. Because this here was in the... wait a minute. I must... Defendant moved for mistrial, asserting that a mistrial substitution violated his Sixth Amendment right to jury trial by denying him the same judge throughout the entire trial. Judge Sayers denied the motion and, after reviewing the transcript of the proceeding, presided over the remainder of the guilt phase and the entire penalty phase of the trial. Okay, so here we have it. Reviewing the transcript. So before that trial commenced, Judge Sayers reviewed the entire transcript. So it's very, very different. Because this, Judge Whittaker, how much I enjoy that she is here, already stated that she does not intend to go back. She just wants to move forward, which makes this completely different, in my opinion. Normal circumstances are, let's see, do we have the timing here? Mid-trial. Dun, dun, dun. Because Judge Sayers replaced Judge Ferguson mid-trial, Judge Sayers did not hear all of the guilt phase testimony, specifically the testimony of Jose Uranga that he had overheard an argument between defendants and an unidentified man, implicated defendant as the... That sounds weak, by the way. Because Judge Sayers did not personally hear this testimony and thus could not possibly evaluate Uranga's credibility, defendant asserts, well, it's not the judge who asserts credibility, that's the jury. That's the problem. Bam, bam, bam. Consequently, it doesn't really say how long into the trial this happened. Yeah, it's hard for me to say, but this definitely wasn't a 6-month trial. Let's just say that. So the circumstances are completely different, in my opinion. Not to mention that he was removed for misconduct. The judge in that case was just sick. Exactly. Yeah, let's see, reference people in which the Supreme Court of California held that a mid-trial substitution of judges does not violate these rights. Now, this is Supreme Court of California. Not one judge in Georgia need to follow what a Supreme Court in another state says. Concerns with directed verdict motions are unfounded. In paragraph 2, defendant Nichols asserts the mid-trial substitution is inappropriate because he claims it will affect his ability to request a directed verdict at the conclusion of the state's case in chief. This concern is unfounded, as a directed verdict of acquittal is only available if the evidence is insufficient as a matter of law. For you who know, one of the trials I covered had a directed verdict. This is not up to the prosecution. The prosecution has absolutely zero to do with how the judge rules in a motion for a directed verdict. They have a right to argue against it. But they cannot say as a fact, as Ms. Love tries to assert here. They cannot and shouldn't even be allowed to argue this. At least not this specific. This is something they can argue when they get there. But here, they have to argue how the judge. This is not a correct argument. C. Issues with familiarity. In paragraphs 3, 4, and 6, defendant Nichols asserts the court advised the parties that she was unfamiliar with the previous trial proceedings, and this would affect the court's ability to rule on motions and objections. In paragraph 5, defendant Nichols asserts the court's level of familiarity violates his due process rights. Defendant Nichols' claims turn upon this court's familiarity with the case. Among those jurisdictions which have statutes regarding the mid-trial substitution of the trial judge, some require the new judge to certify their familiarity with the record. Federal Crim Pro 25. Quote, the judge completing the trial certifies familiarity with the trial record. Massachusetts, any other judge that a court or properly assigned to that court upon certifying in writing that he has familiarized himself with the record of the trial may proceed with and finish the trial. Some jurisdictions with such statutes do not impose such a requirement. People with Cohen, California, imposes no requirement that a substitute judge certify his or her familiarity with the record, and thus authorities from other jurisdictions that do are inapplicable. So these few parts here is what I said earlier. Georgia doesn't have to follow what happens in California or Massachusetts or Washington or anywhere. They don't have to. Georgia does not have such statute. Which one? Again, this is so horribly bad by Adrian Love. She gives examples of jurisdictions that has requirements, and then she gives example of jurisdiction that doesn't have these. And what does she follow up with? Georgia does not have such statute. Which one of them? Jesus. This is so bad. How the flaming F does she have a bar card? Georgia's primary case is McIntyre v. State. While one concurring justice opined that she, quote, would have the replaced judge scrupulously review the prior proceedings and state on the record his or her familiarity therewith, so as to establish that the replacement judge is fully prepared to render informed rulings on any matters that might arise to instruct the jury thoroughly. There is no authority requiring that within Georgia law. The majority opinion itself in McIntyre leaves the matter to harmless error review. Yeah, welcome to Georgia. Regarding the Constitution, I can bet that McIntyre v. State. Let's see what this is. McIntyre v. State, 1995. Okay, that's a murder trial. Dun, dun, dun. Okay, listen here. The murder was committed Now, let me bring it on. There. The murder was committed on January 17th, 1988. McIntyre was indicted on March 1st, 1988. The guilty verdict was returned on June 10th, 1988. So everything here happened within the span of less than 6 months, from the crime to the conviction. He was indicted on March 1st. Indicted doesn't mean the trial started then. So this was, at most, in my opinion, let's see here. Why doesn't it say so? When does the indicted March 1st? Guilty verdict was returned June 10th. So somewhere in that 3 months. But I can bet good money that trial was maybe 2 weeks long. Maybe. Is this a satanic panic? Oh. When evidence is construed strongly in favor of the state and against McIntyre, the jury was authorized to find the following. McIntyre became a member of a satanic group, of which Terry Chapman was the leader. I need to find that trial. Because this late 80s, early 90s was in the height of the satanic panic. Huh. Where is it? During the trial, Judge Robert Noland initially presided but had to leave during the state's presentation of evidence in order to attend the funeral of his infant grandson. Judge Robert James replaced Judge Noland over McIntyre's objection. McIntyre contends that the substitution of judges, blah, 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 blah. Harmless error analysis. Although Hood held that the state must rebut the presumption of prejudice or demonstrate beyond a reasonable doubt that the error was harmless, it also recognized, quote, that a number of courts have held to the contrary and have required that the defendant demonstrate actual prejudice in order to obtain a new trial. Similarly, in Georgia, the temporary absence of a trial judge without suspension of the trial is not a basis for reversal unless the complaining party shows prejudice resulting from the absence. McIntyre has not shown that he was harmed by the substitution, and therefore, under the circumstances of this case, the procedure followed in the trial court does not require reversal of the judgment of conviction. Okay. I need to check. I have a lot to do after this. Nana Misty says, again, not from misconduct, but a death of a grandchild. These are different. Yeah. Let's go back to the motion here. While one concurring justice opined that she would... That's the same... Okay. The majority opinion itself in McIntyre leaves the matter to harmless error. Regarding the constitutional aspect of defendant Nichols' claims, the Supreme Courts of other states which have considered this issue have determined that the mid-trial substitution of a judge does not violate the defendant's constitutional due process rights. Still, how many of those trials were the trial after 6 months? The prosecution wasn't even halfway through their case in chief. People with Thompson in New York, we find nothing in the requirements of due process that indicates that a mid-trial substitution of a judge rises to the level of a per se constitutional violation. So, more or less, there is actually nothing in Georgia. If defendant Nichols' argument about personal or direct observations were correct, then no mistrial replacement could ever be permitted. Maybe it shouldn't. Maybe it should be a mistrial and force the prosecution to start over. Maybe, just maybe, if a trial judge hears half the trial and then pops off, it should be an automatic mistrial and start over. Maybe. Given how well established it is that one judge can replace another judge during a trial, especially when circumstances require it, these arguments are unfounded. Yeah, but you have to look at what circumstances they are. The state see no reason to believe that this very capable court is unable to rule appropriately on motions or objections moving forward. Indeed, given how easily available recordings of these trial proceedings are, the defendants in this case are better off in some respects than defendants in other substitution cases would be, as the parties can and have cited this part. The defense, any one of them, should copy. Well, if this very capable court are this able to rule appropriately on motion or objections moving forward, why do you object this? Why do you object to Judge Whittaker taking a new look on old rulings? Why? Here you argue that she is fully capable of doing it. So why do you argue against it in another motion? Blah, blah, blah. Further, even though Georgia does not have a requirement that the court certify familiarity with the record, the state offers to do whatever it is within its power to do to assist the court in gaining appropriate familiarity. Oh, I'm sure you really, really want to be in judges' chambers to instruct Judge Whittaker on how she should read the transcript. How about you go screw yourself? How about you stay way away from judges' chambers? D. The temporary recess of the trial is not a basis for a mistrial. Defendant Nichols moves for a mistrial given the month-long recess in the proceedings. Defendant Nichols cites no law in support of that claim. Indeed, a month-long recess, though unusual, is not unprecedented. We are going into a 2-month recess. See State v. Campo. Month-long recess occurred during jury deliberations when a jury was in a car accident, which means not the same. It's not the same. It's not even close to the same. State v. Antoine. Defense counsel's illness prompted 2-month recess. Illness, not misconduct from the judge. Corona v. State. Unpublished, then I don't care. The court should again deny the request for severance. In paragraph 8, defendant Nichols again moves for severance based on alleged spillover. This court should again deny that motion. It's well established in Georgia, quote, where evidence of one crime would be admissible in the trial of the other crime, it cannot be said that that trial court abuses its discretion in denying a motion for severance. Then why are 12 other severed from this case? Why is Mondo completely severed from this case? Although this rule is most often recited in cases reviewing the lack of severance as to one defendant's multiple offenses, it has applied in between co-defendants. Here, defendant Nichols and his co-defendants are each charged with a violation of the Georgia RICO Act. So are the other 12. In which the state alleges they engaged in conspiracy. Defendant Nichols' separate actions and those of his co-defendants are alleged in the indictment as overt acts of that conspiracy. I believe Mr. Nichols is mentioned twice in this entire indictment. These are not just separate but related crimes, but the same crime, the RICO conspiracy charge. Then why are 12 other defendants severed from this case? Why are not all 18 in there? A federal district court a federal district court has provided a cogent summary of how the issue of severance of defendants works in a conspiracy case. I don't care. I really don't. Because if 12 people can be severed, then this argument up here is invalid. If they have been severed, then the same argument they place here could be placed against the other 12. And those were severed. In other words, if that argument holds up, then all of them should be there. All 18 of them. Here, defendant Nichols and his co-defendants' acts are evidence of the RICO conspiracy, blah, 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 blah. There are no basis for severance in this case, and this honorable court should deny defendant Nichols' motion. Conclusion: for the reasons stated above, the state respectfully moves this court to deny defendant Nichols' motion for a mistrial. And again, only Adrian Love. Where is the other prosecutors? Why no other signees on this certificate of blah, blah, blah? I can't wait until tomorrow. I really can't wait until tomorrow comes, folks. Because tomorrow, when the hearing starts live, I've already told the office that I'm going home at 1 p.m. tomorrow, my time, which is 7 a.m. your time. So I will be ready, up and going once the hearing starts. And remember, Judge Whitaker, when she says 8:45, she means 8:45.